appeal in the matter of Avon Ground Rents Ltd and Canary Gateway Block A, RTM Co Ltd.
Yes, Mr. Bates.
Yes, thank you. May it please you, my ladies, my lords. First, I appear with Miss Traynor on behalf of the appellant, Avon Ground Rents Ltd, and my learned friend, Mr. Loveday, appears with Mr. Castle on behalf of the respondent, Canary Gateway Block A, RTM Company Limited.
Yes.
Thank you for permitting us to step forward. That made life easier. And thank you for extending
all round.
Well, thank you for extending the invitation to our juniors, but I'm afraid the moving of wires now will prove too difficult to move them forward again. But thank you very much on behalf of both of our juniors there.
Before you launch in, if I can just tell you for your assistance, we've had an opportunity of reading the papers. We've read, obviously, the skeleton arguments, we've read the relevant judgments, and I think we've all dipped into the relevant authorities.
I'm very grateful. And on your desks, hopefully, are two short extracts of material that went wrong in the bundle, I'm afraid. Section 174 of the Housing Act 85, as enacted. We've got the amended version in the bundle, I'm sorry about that. And then Section 77 of the Leasehold Reform Housing and Urban Development Act. It's simply we're going to refer to that as an example of a situation where Parliament specifies shared ownership leases regardless of their percentages. It makes a point one might think is obvious, but always better to have the authority for the obvious, even if in doubt.
Thank you.
My lady, thank you. That was a very helpful indication as to where we are. You'll be fully aware then that what we're dealing with here are two issues, one on the appeal and one on the respondent's notice. So on the appeal, as a question of statutory interpretation in Section 76 of the Commonhold and Leasehold Reform Act 2002, is the qualifying tenant under a shared ownership lease only a qualifying tenant where they've staircased to 100%, or can they qualify under some other provision here because their lease was more than 21 years, regardless of the proportion to which they'd staircased? It's a point of some importance, both for this scheme, as you've seen, different decisions at both High Court and Upper Tribunal level, and with wider knock-on implications for enfranchisement, where much of the same terminology is adopted. On the respondent's notice, this arises if you're with me on the appeal, and it transpires that the wrong party was served. It's what's the consequence? The appeal is largely a question of statutory interpretation, and as you've seen, the decisions that we have below are not at a level that are binding on this court. So we have two Upper Tribunal decisions, one High Court decision, and then the decision that gives rise to this appeal, albeit not the decision under appeal. And because none of it's binding on you, I don't plan to spend a lot of time looking at the lower court decisions. It's statutory interpretation on the appeal,
yes.
Black or white, yes.
I mean, our view was it's actually a pretty short point.
It is. It will take me longer to get there, I suspect, than to make the points. The respondent's notice is possibly slightly longer, because although that's a statutory interpretation point as well, it's a statute in the context of various decisions of this court that have interpreted the effect of the consequences of failing to comply. So I'll deal. What I propose to do is deal with firstly with the statutory scheme, then I'll turn to the slightly convoluted facts that took us to this route. Then I'll deal with the appeal, and then briefly set out what we say on the respondent's notice. I'll hand over to my learned friend to respond on the appeal and develop his respondent's notice, and I'll come back as needed. As I say, it is quite a short point on the appeal, but I'm afraid it may take me a little while to get there because of the slightly unusual procedural route the case is taken. So can I trouble the court then to start with the authorities bundle at tab 2, and I'll take you through the statutory scheme. So as I'm sure you've picked up from the cases below, what we're dealing with here is a scheme whereby qualifying tenants of long leases of flats in properties collectively form a company. The company will take over the management of that block from their freeholder. And you start with section 72, which introduces the qualification conditions for the right to manage. And you see 72.1a identifies two kind of building, two physical erections that can be within the scope of the provisions. The first is the self-contained building, and the second is the self-contained part of the building. So in simple terms, the tower block or something in a terrace. Regardless of whether you're going for the self-contained building or the self-contained part, you have to contain 2 or more flats held by qualifying tenants, so it's not a right applicable to leasehold houses, for example. And then the total number of flats held by such tenants has to be not less than 2/3 of the total number of flats in the premises. Section 73 tells you what a right to manage company is. Private limited company, limited by guarantee, with its articles of association which are prescribed, providing that its object, one of its objects, is to acquire and exercise the right to manage the premises in question. Section 74 deals with who can be a member of a right to manage company. And 74(1)(a) tells you it's the qualifying tenants of the flats in the premises. And then from the date on which the RTM is acquired, landlords under leases have opportunities to join. Obviously, they can't join before that. That would defeat the point of the claim. Section 75 through to 77 then tells you what the qualifying tenants are. So section 75 tells us that a qualifying tenant in subsection 2, if you are a qualifying tenant of a flat, if you are the tenant of the flat under a long lease. 75(3) excludes business tenancies. 75(4) excludes unlawfully granted tenancies. And 75, 6 and 7 simply deal with situations where you've got joint tenancy, etc. So we're starting with 75(2). Are you the tenant of a flat under a long lease? Which then takes you to 76, and this is the key provision for the appeal. 76(2)(a) to F identifies 6 categories of long lease for the purposes of section 75(2). I'll just take you through these. The first in 76(2)(a), a lease granted for a term exceeding 21 years, whether or not it may become terminable earlier, whether by forfeiture or otherwise. That is, in my submission, the standard form of residential long lease. 76(2)(b), a relatively rare beast, I will accept, a lease for a term fixed by law, subject to an obligation for perpetual renewal. 76(2)(c), leases that arise by operation of section 1496. Essentially, as I know you will know, that provision deems certain leases to be terms of 90 years, subject to early termination on death, marriage, as the case may be. 76(2)(d), any lease granted pursuant to the right to buy under Part 5 of the Housing Act 1985, or in pursuance of now very earlier provisions, rights to acquire or rent to mortgage terms under earlier parts of that Act. E, central one to the appeal, if you're a shared ownership lease, whether granted in pursuance of that part, i.e. Part 5 of the Housing Act 1985, or otherwise, where the tenant's total share is 100%, or F, it was granted pursuant to that part, i.e. Part 5, as it has effect by virtue of Section 17 of the Housing Act 1996. That is, by a very roundabout route, the right to buy equivalent for housing associations, which are called the right to acquire. As it happens, the right to acquire is now in the 2008 Act rather than the 1996 Act, but nothing turns on that. For the shared ownership one in 76(2)(e), we also need subsections 3 and 4, further defining what a shared ownership lease is. You see 76(3), there are 2 ways to become a shared ownership lease. One is if it was granted on payment of a premium calculated by reference to a percentage of the value of the demised premises or the costs of providing them. In my submission, that's probably the most common form of shared ownership lease. That's the you buy 30% share at the beginning. Or B, under which the tenant or his personal representatives will or may be entitled to a sum calculated by reference directly or indirectly to the value of those premises. And then 4, total share, because of course in 2E, total share has to be 100%. Total share means the initial share plus any additional shares which he has acquired. And that's a process that in shared ownership lingo is known as staircasing. For completeness, we should just look at section 77, because section 76.1 directed us to go and look at 77 to tell us also what is a long lease, although I don't think it will help us on the appeal. 77.1 is simply a further description of when a lease is terminable on death, marriage, etc. So it's adding meat to the bones of 76.2c. 77.2 is about scenarios where a long lease has come to an end and a new tenancy of some sort has been granted. 76.3 is about leases with covenants for renewal that are not perpetual renewals, so slightly different to 76.2b. 77.4 is the statutory holdover provisions when leases expire through passage of time. And then 77.5 is simply making provision for aggregating leases together where you've got two or more leases of a single flat. I don't think that's where the appeal turns, but for completeness, that's the descriptive provisions. You then have if that's the qualification conditions, you then have the procedural provisions starting at section 78. So assuming you've got buildings and leases that qualify, 78 and following tells us how you exercise the right. And 78.1 tells us that before making a claim to acquire the right to manage any premises, the RTM company must give notice to each person who, at the time the notice is given, is the qualifying tenant of a flat contained in the premises, but neither is nor has agreed to become a member of the RTM company. So it's everybody who's not actively involved already has to be told that the possibility of the RTM process exists. The remainder of section 78 deals with the form of that notice inviting participation. I won't trouble you with that, I don't think the appeal turns on that. Section 79 is the next notice. So after your notice inviting participation, you move to your claim notice. And 79.1 and in particular 79.2 are important for the respondent's notice point. So the claim to acquire the right to manage 79.1 is made by giving notice of claim, referred to in this chapter as a claim notice, and the relevant date in relation to the claim means the date on which the notice of claim is given. The claim notice may not be given unless each person required to be given a notice of invitation to participate has been given such a notice at least 14 days before. And the way the Upper Tribunal has interpreted 79.2 is that should be read as a sanction preventing you from invalidating effectively claim notices where you haven't given a notice inviting participation to each relevant person. It's not merely a provision that says you've got to make your best efforts and do it within 14 days. Section 80 deals with the content of the claim notice. Again, I don't think we need to come to that. I'm not sure the appeal turns on that. Section 84 deals with the third of the three statutory notices that might be served, the landlord's counter notice. And you see in 84.2, the landlord has the right, but not the duty, to serve a counter notice, and if so, it must contain one of two statements. It either admits that the RTM company was entitled to acquire the right to manage, or alleges that, by reason of a provision of this chapter, was not so entitled. Assuming there has been a negative counter notice, then 84.3 tells you that it's the RTM company's obligation to apply to in England, the first tier tribunal, in Wales, the LVT, for a determination as to the question. The tribunal then, we haven't put them in the bundle, it doesn't really matter, the tribunal deals with those in the usual way, directions, etc., etc. Assuming you succeed in your RTM claim, what do you get? And just very briefly here, take you to section 96, so as to understand what's passing on a successful RTM claim. It's section 96.2 that is the first descriptive provision. It's the management functions of the person who was a landlord under the lease. Those instead become functions of the RTM company. So what are the management functions? Well, they're defined in 96.5. Functions with respect to services, repairs, maintenance, improvements, insurance and management. I'm sure the court's appreciated, that's lifted from the definition of service charges in the Landlord and Tenant Act 1985. So the simplest way to think of it is the service charge functions go over. And then it's not only that, sections 98 and 99, just flagging them exceptionally briefly. The other thing that goes over of some significance is the RTM company then starts to play a role in giving of approvals under leases. It's not an unqualified role. It depends upon the nature of the covenant in question. In very general terms, the RTM company can't give its permission unless it's first asked the landlord what its view is, and it can't give permission if the landlord hasn't first given permission. But if the landlord is silent, for example, it becomes the RTM company's unilateral choice. So you don't find that all decision-making goes over, but a role for the RTM company is then created in the giving of approvals. So it's quite a significant transfer of rights and obligations under these schemes. With that brief introduction then, let me turn to the slightly convoluted factual background, because as you've picked up, I'm sure, the actual reasoning that we're challenging in this case, of course, is in a different judgment between the same parties. One thing that might be helpful is if I can ask you to start in the supplemental bundle at page 51. We have a photo, so beloved of property lawyers. We'll try and see what we're grappling with.
Not quite as much as plans, though.
Not quite as much as plans, no.
Page 51.
51, yes, please. So if you see there, you've got the 7 different houses that are outlined. The whole of that site, with those 7 houses on it, the freeholder is my client, that's Avon. We're concerned with what's become known in this litigation as Block A, which is the top 3 houses, Edgemere, Vale and Elite. So in Elite, you have 57 flats, each let on long leases in the normal way. In Edgemere, there's a head lease in favour of Metropolitan Housing Trust. And then out of that head lease, Metropolitan has granted 17 occupational leases on shared ownership terms.
And what's it, 5, is it, that have staircase?
Exactly, 5 have staircase. At the time of the first litigation, it was 2. At the time of the second litigation, it's 5. So 5 of the 17 have got to 100%. The rest are somewhere short of that. But all of those leases are for terms of more than 21 years. And then in Vale House, again, there's a head lease held by Metropolitan Housing Trust. And out of that, they've granted 23 assured tenancies, normal social rent tenancies. So the only long lease there is Metropolitan's head lease of the whole building. The bottom 4 properties, Wessex, Birkdale, Slate and Laing, those are collectively known as Block B. They don't arise on this appeal, but they were in the first appeal, so when you see references to Block B, it's those 4 that are being dealt with there. And it's common ground that each of those 2 blocks, Block A and Block B, they meet the physical qualification conditions because each of them is a self-contained building. Now, the best place to start for understanding the background, if I can, is the previous Upper Tribunal decision, so the one not under appeal. In the core bundle at page 65. And this is from the end of 2020. My own friend and I appearing before the then Chamber President, Mr. Justice Fancourt, by Skype for business. And paragraph 1 just tells you that back in January 2020, the first tier tribunal had determined that both of the blocks, Canary A and Canary B, have been entitled to acquire their right to manage. We appealed that for both blocks, and you get the procedural background, paragraphs 5 to 10. The critical bit for the appeal going forward is paragraph 10 about the shared ownership leases. Of the 17 in Edgemere, 2 were understood to have been staircase to 100%. The other 15, less than 100%. It's now, as you pointed out, 5 and 12. But the point remains the same. And the first issue on the appeal was whether those 15 tenants, now those 12, were qualifying tenants for the purposes of the Act. The Upper Tribunal held they were qualifying tenants, and its reasoning started at paragraph 26. So it starts in paragraph 26, the opening sentence, by going first to section 76(2)(e) and noting there's express provision for shared ownership leases. It's not limited to them being granted under a particular statutory scheme. They can be under any scheme, public or private law, so long as they are within the type identified. The reason for this, they say in paragraph 27, is because shared ownership leases have long had a life outside of statutory provisions. An old case from 1983, an example of a charity granting a shared ownership lease. And then at paragraph 30 onwards, the then President reviewed the various case law to date. He started with a case called Brick Farm, which was under very similar provisions of the Leasehold Reform Housing and Urban Development Act 1993. It wasn't actually about shared ownership leases, that case. It was about an exception to do with functional land of charities. But in the course of it, the High Court grappled with the meaning of the phrase long lease. And paragraphs 31, in fact, or just 31 actually, because it's the indented quote, summarises what Mr. Justice Stanley Burnton held in that case. It was argued that since all shared ownership leases are for leases for a term exceeding 21 years, the provision for the inclusion of some shared ownership leases as long leases was apparently otiose, and that to avoid the conclusion, it was necessary to read the provision for leases for a term exceeding 21 years as meaning such leases other than shared ownership leases. That was rejected by Mr. Justice Stanley Burnton, and his reasoning is set out in the indented paragraph. The next case that was considered is set out at paragraphs 32 to 35, a case called Midland, Hart and Richardson. This was a case about possession proceedings and whether or not the relevant safeguards for long leases had been complied with. And in that case, the tenant had not staircased to 100%. And the Deputy Judge's view, paragraph 34, was that as she only had her initial 50% share, she didn't have the 100% share, so she didn't fulfil the condition in section 76(2)(e), and so it was not a long lease as defined. But as Mr. Justice Fancourt noted at paragraph 35, Midland Hart doesn't refer to brick farm management. And then we have at paragraphs 36 and 37, a case that was more on point, a case called Corscombe Close, which was actually about these provisions, in which the Upper Tribunal, Judge Mole QC, sitting as judge of the Upper Tribunal, had to grapple with the question that's now before you. And Judge Mole, it's his paragraph, it's 37, the indented paragraph. Judge Mole identifies the two constructions of section 76(2). You can either read it as a series of gateways, so if you meet any of those qualifying conditions, you pass, or you read it as a sieve, so that it's all well and good to pass the general 76(2)(a), but if you're caught by a more specific provision, it's the specific provision that governs. And he concludes gateway, essentially for the reasons that Mr. Justice Stanley Burnton had given in Brick Farm, that these weren't provisions about narrowing, they were extending provisions. And the argument I put on that occasion to the then President is very similar to the one I put now. The very simply, as we say at paragraph 38 there, it's almost impossible to imagine circumstances in which you have a shared ownership lease of less than 100%, sorry, less than 21 years. Express provision is made for that. Therefore, that should be the approach. And the President rejects all that. Paragraph 42. However unusual it might be in practice, it's possible to grant one for less than 21 years. And so that explains what section 76(2)(e is doing. It's catching that residual category rather than being a general descriptive category for that entire class. So my argument there failed, but ultimately the RTM claim was defeated for entirely different reasons. At paragraph 69, the Upper Tribunal concluded that in respect of the socially rented flats, Metropolitan Housing Trust was the qualifying tenant, and therefore it should have been served with a notice of invited participation, and it wasn't. And so issue 3 is the President grappling with what's the effect of failure to serve someone who should have been served. And he concludes, after a review of the authorities, paragraphs 81 through to 90, he concludes, jumping straight to the end, the first sentence of paragraph 90, he concludes that section 79(2) that we looked at earlier, so the provision that you must have given the notice of invited participation to all qualifying tenants at least 14 days beforehand, he says that the consequence of not doing so is to invalidate your claim notice because your claim notice cannot be given at a time when you have not complied with the earlier provisions. So we don't get into the question of did Parliament intend invalidity or not, because he says it's dealt with on the statute. The statute deals with invalidity. We're not doing an interpretive question of asking ourselves what did Parliament consider the outcome to be. It's told us, and that's the respondent's notice point. So that was the end of round 1 of the litigation. We then come to round 2, which gives rise to this appeal, and we're still dealing with the 17 flats at Edgemere House. Now, for completeness, to make clear what's common ground. It's common ground that the notice inviting participation was served on all 17 of the shared ownership tenants. It's common ground that 5 of the 17 have staircased to 100% ownership. So it's common ground, therefore, that 12 haven't. And it's common ground that no notice of inviting participation was served on the housing association at Edgemere House. But it is also common ground, as my learned friend will want me to stress, that the housing association did receive notice inviting participation for other properties.
Okay.
Quite. Because having got that wrong first time round, they didn't make the same mistake again. So we took, when the RTM claim is then relaunched, it comes before the tribunal, page 137 of the core bundle. In March of last year, a learned friend and I once again returned to repeat the arguments we've made previously in front of Judge Sheffield, who, as he reminded us, was counsel in the Causton Court case.
So this is your third outing on this.
Our third outing, and that RTM, and that last one at the RTM, a shared ownership loving, with everyone involved spending lots of time on shared ownership cases. We took 3 points, if you look at my paragraph 10 of the FTT's decision. Points 1 and 2 were new, didn't impress the FTT, didn't impress the Upper Tribunal, and no more needs said about them. Point 3 is the shared ownership point.
Yep.
And as I say, we accepted, as we had to in the FTT, we can't possibly win on that point. Having run exactly the same and had Mr. Fancourt reject it,
Yep.
the Tribunal were bound to reject it, and as they note, it was simply for the purpose of preserving the appeal. So we failed on the first 2 points. The third issue didn't arise because we had to lose. The FTT refused me permission to appeal. If you look at page 127. Ground 4 is what becomes the shared ownership argument in this court. Must refuse permission to appeal because it's bound by the prior decision of the Upper Tribunal. But as you'll appreciate under the rules, one has to ask, even if there can only be one outcome. The Upper Tribunal did grant permission on that point, but then dismissed it. So page 102. 101. Sorry, I should say where it starts. Permission appeals refused on grounds 1, 2, and 3, which is me attempting to revive the earlier points if he'd rejected, but granted on ground 4, which is the shared ownership point. And ground 4 starts at paragraph 5 of the permission decision. Identifies that it's an issue of law that was decided in the previous round of litigation. We were unsuccessful on that issue, but succeeded on another issue, and therefore we couldn't challenge that reasoning in the Court of Appeal. The appropriate course, paragraph 6, is to grant permission, but then dismiss the appeal for the reasons given in the earlier decision, and then leave us to seek permission from this court. Paragraph 7, the shared ownership issue only relates to Block A, so Block B has their RTM confirmed. And then paragraph 10, subject to submissions by the respondent, because the order had been made without reference to them, of course, the tribunal will dismiss the appeal in due course. And that is what happened at page 99. After a preamble setting out how we got to this stage, over the page at 100, the appeal is dismissed. I have to apply to the Upper Tribunal for permission to appeal to the Court of Appeal by the 5th of July, because the rules compel me to, even though it's a second appeal, slightly unusually. I made that application and it was dismissed. Page 64. The Deputy President of the Upper Tribunal agreed in the third paragraph that it was a point of general importance, but as the issue had been decided now numerous times at Upper Tribunal and High Court level, it should be left to the Court of Appeal. And finally, therefore,
so one feels sympathy for the deputy judge, referred to at page 64.
Yes, quite.
Yep. And
Which
so
then
here we all are.
Then finally brings us to page 62. Lord Justice Arnold granted me permission to appeal. And for completeness, you've been very kind indulging me taking you through this background. Just page 61. An order of Master Bancroft Rimmer. You see paragraph 1, the parties have agreed the cost position. It's the same costs as below. In the event that Rule 13 of the First Tier Tribunal rules are not instantly to my lady's mind, effectively, unless one party behaves unreasonably or engages in wasted costs, it's an award of costs on the appeal. So in reality, this is an award of cost appeal to determine a point of some practical importance to everyone involved.
Yes.
With that in mind, and thank you very much for that indulgence, I'll then turn to the argument on the appeal. And my proposition on the appeal is this. A shared ownership leaseholder is not a qualifying tenant for the purposes of section 76(2) unless and until they have staircased to a 100% interest in their flat. If that's right, then the consequences are that only 5 of the 17 leaseholders at Edgemere House were qualifying tenants. It means that the housing association was the qualifying tenant of the other 12 flats, and it was not served with notice inviting participation for those flats, so we say the claim fails. And that's where the respondent's notice comes in, because Malone and Friends says that properly construed, failure to serve in those circumstances would not be fatal.
Yep.
Now, before we get to that, I obviously need to make good my proposition but a shared ownership leaseholder has to staircase.
Tell us about your SIP.
So let me then take you to that. Can I just take you then back in the authorities bundle to page 11 behind tab 2 on section 76. So we say the way one reads these 6 categories in 76.2 is 6 separate descriptions of classes of lease. There is no overlapping between them. So if you have a shared ownership lease, you need to qualify under section 76.2e or not at all. It's not open to you to use the general provision in 76.2a and ignore the specific provision in 76.2e. And we effectively have 3 reasons for that. The first is we say that that is the natural reading of the section. Parliament has identified a particular form of tenure, shared ownership, defined it in some detail, see sections 3 and 4, and then made specific qualification for how that tenure fits into the Act. It's quite wrong to use a general provision to go behind the specific provision. Secondly, we say that the pre-legislative materials put the point beyond any doubt. As you've seen, I'm sure, in the skeleton. On 2 of the 3 previous occasions this legislation has made its way to this court. The default has been to reach for the consultation paper to try and understand it, and the only time it went to the Supreme Court, their lordships also went to the consultation paper to understand it. So I'm going to take it as read, if I may, that the consultation paper is admissible material here, and we deal with it in the authorities bundle at tab 15. And it's page 252 of 270. Eligibility criteria. For consistency, we propose that in general RTM should be exercisable by those leaseholders who would be eligible for collective enfranchisement. The right will be exercisable by qualifying tenants as defined in the 1993 Act. These are essentially leaseholders with a lease which was originally granted for a term exceeding 21 years, and this is the critical bit. Where the lease in question is a shared ownership lease, the leaseholder would have to hold a 100% share of the equity. The reference, just for completeness, earlier on in that paragraph to where it says that the RTM right would be the same as right for collective enfranchisement. This is a consultation paper, of course, from 2000-2001. The Brick Farm case, which might be thought to cast doubt upon my argument, isn't until 2005. So the author is not aware of the line of argument that finds favour in Brick Farm because it hadn't happened by that stage. So at the time this is being put forward, I say it's clear that the intent was the leaseholder had to have staircased to 100%. My learned friend says, just turn over the page to paragraph 18 of the consultation paper on page 253. And my learned friend says, well, look, under exclusions here, they don't say anything about excluding shared ownership leases where the provision is less than 100%. I'll just make 2 brief points about that. That's the wrong way of looking at it. It's not about excluding, it's about identifying who qualifies. And you don't qualify until you get to the 100%. And secondly, these exclusions actually end up turning up in other parts of the Act. So this is we haven't put it in because it's not directly relevant, but those examples at Roman numerals 1 to 4, 1, 2 and 3 end up making their way into the Act in Schedule 6, certain general exemptions. The one that you might think is interesting is 18 Roman numeral 3. Can't apply against a local authority for the right to manage. That does make its way into the Act. It's in Schedule 6. Given how much time we've all spent looking at right to buy leases, you might wonder why we spend so much time looking at right to buy leases when you can't right to manage against the local authority. But there we are. So we say the second of the two criteria, second of my 2 points is the pre-legislative material is clear. And then the third point we say is that Malone and Friends construction and the one that appealed to the President of the Upper Tribunal reduces sections 72D to F, so right to buy, right to acquire and shared ownership, reduces them to practical irrelevance. And we give examples in our skeleton at paragraph 20. I'll just take them quite quickly. The first is, you remember, of course, 76.2D says that right to buy leases qualify. So if we just go back in the authorities bundle, tab 2, page 11, or my skeleton is paragraph 20. So a right to buy lease qualifies by virtue of 76.2D. But it's almost impossible to imagine circumstances in which you could have a right to buy lease for less than 21 years. I've come up with one scenario in the skeleton which I thought might work to have a right to buy lease of less than 21 years, even assuming you could find anyone who wanted to buy it at such a short period, and it wouldn't be mortgageable in any event. But I'm actually not sure that even that's right. I'm actually not sure you even can have a right to buy lease of less than 21 years. And just briefly, in Brick Farm at tab 7, it's paragraph 16 of Brick Farm, page 148 of the authorities bundle. So the judge in Brick Farm considered actually it was probably impossible to have a right to buy a lease for less than 21 years because there has to be a minimum term of 50 years held by the landlord in order for the RTB to apply. He thought that indicated that the RTB provisions were otiose. I say that, no, that's wrong. Whether it's exceptionally rare so as to never rise in practice or impossible, the implication is the same. Parliament's not legislating for a tiny class of right to buy leases that somehow didn't qualify under 76.2a. Parliament's legislating for the general descriptor of right to buy leases.
So just in relation to paragraph 16, and I follow your point about exceptionally rare, as to the reason that the judge gives for really being impossible, is he right about that?
That is what paragraph 4b of Schedule 5 says, having been to look at it last night and checked that.
Does it? I mean, if the landlord's term has to be of a certain length, does that mean that the tenant's has to be as well?
Yes. So we've got the RTB provisions in. So if you go to tab 1, page 4, this tells you how long your RTB lease is going to be.
Yes.
So Schedule 6, paragraph 12.1. If the landlord's interest is not less than a lease with more than 25 years and 5 days unexpired, the appropriate term, i.e. the term of the RTB lease, is not less than 125 years. And in practice, I'm sure my lord and ladies know, in practice, generally the local authority is the freeholder. It has got a term of more than 125 years. So you almost invariably, in a normal case, see RTB leases for 125 years. And that's why 12.2 deals with circumstances where you've got any other case in which case you get 5 days less than the local authority's term. 12.3 is a slightly strange provision, because what 12.3 enables local authorities to do is have the same term date for each RTB lease in the building, regardless of when it's granted. So they could be confident of getting all the flats back on one day. So I suppose you could have a situation where it's technically granted for a longer term, but it will actually end on the date calculated by reference to the first RTB lease in the building. But I'm slightly reluctant to go too far into the mechanics of the RTB, because on either of the constructions, either it's vanishingly rare or impossible, they both point to, I say, a conclusion that they're not legislating for that tiny class. They're legislating for a general descriptor.
And staying with what you're probably right is irrelevant. Just thinking about what Mr. Justice Stanley Burnton says, the landlord's term has to be 50 years or more, and that's at the time of the
grant.
Yes.
Yes. So I was thinking last night of all kinds of strange scenarios where you might be able to end up with, although the landlord has a term of more than 50 years, the expiry date was inside 21 years. And I can construct scenarios that achieve that, but they're getting really quite obscure. And for the purposes of the appeal, as I say, whether it's impossible, which is what Mr. Stanley Burnton thought, or very rare, which is what Mr. Fancourt thought, they both point the same way. Parliament hasn't legislated for that tiny residual category. It's legislating for the descriptor. And the other reason, of course, for not placing too much weight on the RTB provisions, although I do say they help us, is you can't go for an RTM where the local housing authority is the immediate landlord of anyone. So these provisions that RTB leases qualify as long leases only matter in buildings where the local authority isn't the immediate landlord of anyone. So either it's granted a head lease to some sort of private company, or you've got a block of, say, 4 flats, they've all RTB'd, and then they've enfranchised. Their leases would still be RTB leases, because they all have to say on the front of them, RTB leases, they all have prescribed wording, etc. But they've all enfranchised, so the local authority's role is now almost nothing. But the way that it's approached, respectfully I say, by the President in this case, it reduces it to, on his analysis, almost irrelevance. And it may be that even almost irrelevance is too generous. Either way, it doesn't help with the construction point, because Parliament isn't legislating for a tiny category. It's legislating for the broad descriptor. And it's the same point with the right to acquire leases under F. Right to acquire with housing associations being in substance the same. It incorporates Part 5 with necessary modifications. So then you ask yourself, well, in relation to E, which is the one in this appeal, was Parliament legislating for a scenario where a shared ownership lease of less than 21 years, which is nonetheless held at 100% interest, or was it legislating for the broad class of shared ownership and saying that shared owners only have this right once they have staircased? And we say it's legislating for the latter. Shared owners as a class only have this right where they've staircased. And that then takes me in nicely to what's said against us by my learned friend, because he takes 3 points against us. And the most powerful, it seems to me, is his policy argument. He says, well, why would Parliament exclude a shared owner who's got a 90% share in the property? They're paying all of the service charges. They've got by far the biggest capital value because they've got a 90% share. Why is Parliament excluding them? Which on my analysis they are, I accept. So, to which I say there's 2 answers. The first is that Parliament has to draw a line somewhere for qualification, and it's chosen to draw the line at 100%. It could have drawn it somewhere else. I agree. And in the little pack we handed up, you've got Section 77 of the Leasehold Reform, Housing and Urban Development Act 1993. If I can just take you to that exceptionally briefly. That's a provision that gives qualifying tenants the right to have an external surveyor come in and audit their landlord's management functions. Look at 77(2)(b). It's a right given to shared owners regardless of the share they own. So Parliament could have drawn the line elsewhere, it didn't. But secondly, and perhaps more substantively, it's important in my submission to recognise that shared ownership leases, where you haven't staircased to 100%, are conceptually different to normal long leases, and are conceptually different to shared ownership leases where you do hold 100%. Because in any shared ownership lease where the tenant holds less than 100%, the social landlord provider normally retains a significant interest, whether financial or stock management, in that flat. And we can see that from the model lease of a shared owner at this building. So in the supplemental bundle, can I take you to page 85? So we're in there, we're in one of the shared ownership leaseholders' leases. And clause 3.19 shows you what kind of interest housing associations retain until you get to the 100% ownership status. So clause 3.19 is dealing with situations where the leaseholder wants to assign the whole or part of the premises. And it applies during the preemption period. The preemption period is defined as any time before you've staircased to 100%. I can give you the references for this at the moment, but I've been through all these. So any time before you've staircased to 100%, then unless clause 3.19.5 applies, and just sketching down there, you can see that's assignments arising by operation of law. So if you're trying to sell it, is what this is about, then you have to comply with 3.19.2. And 3.19.2 says that where you want to assign it, you first have to serve notice on the landlord, accompanied by a valuer's certificate, which gives you the value of the property at the given date, offering to surrender the lease. And then the landlord has to elect. It can decline the offer of surrender, but nominate a purchaser, because of course they'll have a waiting list of people who want to purchase shared ownership properties. Or it can accept your surrender and buy you out. That's very different to normal long leases. You would never expect to see that in a long lease of a flat bought on the open market of a quote-unquote normal block. So when I say shared ownership leases are conceptually different to long leases, well, there's a good example of it. The housing association retains an interest beyond pure monetary terms until you staircase to 100%. Once you've staircased, it's yours. But until then, the housing association continues to play a role. And that, in my submission, is most likely to be the reason why Parliament set a 100% threshold. It fits with how shared ownership is used in the real world. A similar friend had 3 points against us, of which I thought that was his best. His other 2 points are, he says you can have shared ownership leases for terms of less than 21 years, or right to buy leases for terms of less than 21 years. Well, I accept that, but that all just begs the issue on the appeal. Is Parliament legislating for that, or is it the broad descriptor? And secondly, he places great weight, it was his first point in his skeleton, on the fact that after section 76(2)(e, there is an or. So if we can just pull this up quickly. Page 11 of the authorities bundle. He is clearly factually right that there is an or after E, but respectfully, that doesn't take you anywhere. That doesn't tell you whether it's legislating for whether when you read this as a whole, having regard to all the admissible background material, etc., that doesn't tell you the answer to this appeal. We know that they could have put the or anywhere. They could have had an or after every provision. They could have written the act slightly differently. The or isn't the answer to this.
Does it not mean that it is enough to be within any of A to F? I mean, that doesn't dispose of the point, because you still have to work out what A means. But the or suggests that it's enough to be in any of them.
Well, or it could be that it's setting up F as an equivalent to E, because you don't have or after A to B, B to C. I see the point. I mean, of course, I see the point.
And there must be an implied or everywhere, mustn't there? Because you can't say you have to be in A and B.
No, quite, and that's not my case.
No.
So my case is, it's 6 hermetically sealed categories.
Yes.
And most people are going to pass under 76.2a. But if you've got one of the then further described categories, further particularised categories, the specific trumps the general.
And what you're in effect saying is that A has to be read more narrowly.
Yes.
I don't know whether B or C has to be read more narrowly as well. Probably not. But it's A that has to be impliedly limited by reference to the later categories.
Correct, yes. Yes, but B and C are so rare that I query whether I should say anything about them, because the scenarios in which they arise are likely to be so unusual.
But what it does tell us is that there are very unusual scenarios set out in this section.
I accept that, and you could make the same.
So it's catering for the very unusual or vanishingly rare.
And you could make the same point further against me by looking at 77, as we did, countering for even rarer scenarios. That doesn't, though, in my submission, overcome what we say is the cumulative weight of the 3 points we took. 1, natural reading. 2, clear pre-legislative indication. And 3, we just say inherent unlikelihood of legislating for a class that's so general in 76.2a that we then make provision in the next 5 sections for things that, at least in one case, could possibly never happen, but certainly on any view are all very, very rare. No, it's A as the general one, subject to the specific provisions. As Judge Moore put it in Course Concord, it's not gateways, it's sieves.
I'm not quite sure I understand the civ.
Yes, I've spent 2 days. I've spent 2 days wondering if I can come up with a better analogy, and I'm not sure I have.
I think you've done just fine.
because that isn't really your point. Your point is A has to be seen as impliedly limited.
Yes.
It isn't that you pass through A and then have to get caught by something further on.
No, it's that where you've got a descriptor to which B to F applies, that's your qualification route. You don't use A. So, as I say, the vast majority of normal leases on the open market will pass under 76.2a. But where you are dealing with one of those special categories, the special rules are set out. As my lady rightly indicated, it is a narrow point, and I think that probably is the point. Can I turn then to the respondent's notice briefly, because I want to just flag up what we say, so I can give my learned friend targets to shoot down, if I may. Of course, this only arises if you're with me on the appeal. So logically, at this stage, one's determined the housing association should have been served at these 12 properties. So what's the consequence of the failure to do so? This is a topic that this court has grappled with on at least 5 occasions in the last 5 years, starting with Nat and Osman. But can we actually look at Elim Court, which was the second chronologically of the cases to grapple with this question? But it's about this scheme, so it's a helpful one to look at. And Elim Court is behind tab 11. And it's a series of alleged procedural failures under the right to manage legislation, where it is fair to say Lord Justice Lewison does not find favour with my submissions. The important point, and the point of general principle, is paragraph 49 and following, where Lord Justice Lewison reiterates and then explains the Nat case in the context of this scheme. And he starts at 49 by saying that we've moved away from the old mandatory and directory distinctions that used to apply. Because that, as has been said in Nat, that really doesn't do anything more than state a conclusion as to the consequence. The proper distinction, he says in paragraph 50, is to draw the distinction between public and private law. So in cases involving a decision of a public body, and cases involving a property right or similar. In the first case, decisions about a public body, paragraph 51, substantial compliance might be good enough. And as I'm sure you know from having read the cases, it's all the immigration cases they cite where someone uses a slightly out-of-date form that the Secretary of State's produced, and it would be monstrously unfair to invalidate their asylum claim on that basis. But then in private law, paragraph 51, it's different. The Court of Appeal cases show a consistent approach in relation to statutory requirements to serve a notice as part of the process for a private person to acquire or resist the acquisition of property or similar rights conferred by statute. In none of them has the Court adopted the approach of substantial compliance. The Court has interpreted the notice to see whether it actually complies with the strict requirement of the statutes, and if it does not, then you hold as a matter of statutory interpretation that it's wholly valid or wholly invalid. So whilst public law may have that more nuanced take, private law binary, valid or invalid. But invalidity doesn't necessarily mean the whole claim fails. As he explains in paragraph 52. Because you're trying to identify, second sentence, it's the intention of the legislature in cases of invalidity. And you're identifying that in the context of the scheme, unless, or rather where, not expressly stated in the statute. So with a private law error, valid or invalid, if invalid, does the Act tell us what the consequence is? If yes, we apply it. If no, we have to ascertain what Parliament intended, and which is a question of statutory interpretation. And then he gives us a series of pointers. Where the defect is of critical importance in the context of the scheme, non-compliance generally relates in invalidity. Where it's secondary or merely ancillary, then it may nonetheless be held to be valid. Is it particularised in the statute, or simply provided by some general provision? With in the latter case, general provisions likely to be viewed as secondary importance. Is it required by the statute or by subordinate legislation? Subordinate legislation likely to be viewed as secondary importance. And then lastly, a third is whether the server of the notice may immediately serve another one if the impugned notice is invalid. If he can, that's a pointer towards invalidity. Now, my learned friend, in his respondent's notice, develops a number of reasons why he says that actually this should be in the not invalid category. But respectfully, I say before he gets to that stage, he's got to grapple with the words in brackets in paragraph 52, where not expressly stated in the statute. Because as the President held in the first round of Upper Tribunal litigation between us, the correct reading of 79.2 is that there is a sanction for failure to serve a notice inviting participation. You can't give the claim notice. It must therefore follow, says the President, that it is invalid if you try to do so. And we say that's the answer to the respondent's notice. It's not about prejudice. It's not about whether or not notices inviting participation are of central importance or secondary importance. What he has to grapple with is the Act provides the sanction, and Parliament has made that choice. Now, if you're not with me on that, then we do end up having to apply the pointers identified by Lord Justice Lewison. And I broadly rely upon everything the President said last time round. So just as headline points, this material is of central importance, as the President explains last time round. The key thing about the notice inviting participation is that's how you join the RTM company at the earliest possible stage. That's how you get a chance to influence what goes in the claim notice. Conceivably, although I accept this is probably not very likely, conceivably the scope of the claim. Questions about who the managing agent to be appointed will be. Questions about who to instruct as solicitors if there's going to be litigation. If you're not in at an early stage, you don't have the chance to influence all of those factors. Is the information particularised in the statute? Well, yes, you've seen the NIP provisions themselves have a number of factors that have to be included, and then secondary legislation can add to them. But this isn't one where it simply says, there shall be a form, the Secretary of State shall craft it. So it is one of those forms that is particularised in the Act. Can a new notice be served immediately if the impugned one is invalid? Yes, and this is the critical difference between right to manage legislation and the enfranchisement legislation that people frequently draw upon as a comparator. You'll know under the enfranchisement legislation that if your notices are invalid, you have a 1-year bar before you can do anything. There's no such bar here. It's perfectly possible in response to a negative counter notice to simply withdraw your claim notice and serve another one the next day. There is a consequence. You're always liable as an RTM company for the costs of a claim notice you serve. That's Section 88 of the Commonhold Leasehold Reform Act 2002. But that's not a bar on giving a new one. Now, I suspect when he comes to address you, my learned friend is going to stress that the Housing Association did receive the notice of inviting participation for other flats. And I respectfully just say, but the answer to that is the first sentence of paragraph 52 of Elim Court. The answer does not depend on the particular circumstances of the actual parties. Now, he was kind enough to flag this up to me in a phone call last night. I suspect he's going to draw a slightly more subtle point in response to this. I expect he's going to say that it's important to remember there are these 3 houses at this block. At Vale House, the Housing Association got 23 notices inviting participation, 1 for each of its flats under its head lease, the ones that are all rented to the social tenants. And I suspect he's going to say, well, why isn't that an answer to everything? Because he's going to say that actually, properly construed, what matters is you give the notice of inviting participation to the qualifying tenant. You don't have to give 1 per flat, or even specify 1 per flat. What matters is that they get it, because then they're on notice of the process and they can take investigations and carry out their rights. Just very, very briefly, because I'll let him develop that rather than preempt too much.
That's right.
I mean, and say this is very fair to him. He put me on notice of this last night, because that's not how it's put in the skeleton. In the skeleton, it's put as a reasons why we can distinguish Canary number 1. Very briefly, of course, there's a factual difficulty with developing all that, is we don't actually have the relevant notices here, nor did we interrogate them below, because that hasn't been the argument. So it may be that what he's going to ask for is remission to have that dealt with, and if so, we can deal with that. But if that is his point, I don't necessarily accept that you can give a global notice, even if that was done here. And I can deal with why, but probably best to do that in reply. I flag that not to be unhelpful, but simply because he was kind enough to raise this point with me yesterday. I can deal with it at level of principle, and I'm happy to deal with it at level of principle.
Let's hear what he says.
Quite. Can I just take a moment to check the train? Thank you very much.
No, thank you very much. That's very clear.
I'm grateful to my learned friend as ever for having taken you through a quick canter through the legislation and the scheme of the Act. This is, just in relation to this particular property, I think the 4th time there has been an oral argument. argument in relation to substantially the same issues.
They certainly
at
don't want you
times
to take over this building, do they?
Well, it's 50% there already. It's the other 50% that is an issue for purposes of this appeal. As I was going to say, it's often easy to neglect the fact that not everybody is as familiar with the right to manage as those who seem to find themselves on opposite sides in these cases time after time after time.
Well, the description was very clear, and I think
in essence, there are two issues. The issue of some significance, as my learned friend indicated, not only the shared ownership issue not only goes to the rights of many hundreds of thousands of shared ownership leaseholders who have not staircased to 100% in relation to the right to manage, but given that the legislation, the 2002 Act, mirrors almost identically the wording of the enfranchisement legislation, in particular collective enfranchisement, there is obviously a potential knock-on effect in relation to those kind of rights as well. As far as the second one is concerned, it really is yet another Nat and Osman case involving yet another defect or perceived defect in procedure. And as my friend has indicated, they've already been before the courts on this court on more than one occasion in recent years. Although there is this factual glitch, and we do have to address the consequences of the factual differences between this and Canary Gateway, and I'll take you on to Canary Gateway number 1, and I'll take you on to that in due course. If I can start with the interpretation issue, the main appeal. In essence, we say that the the High Court in the appeal in Brick Farm, the Upper Tribunal in Corsican Close, and Canary Gateway number 1 approached these provisions, or in the case of Brick Farm, the equivalent provisions of the 1993 Leasehold Reform and Housing Development Act, in the correct way in terms of the broad interpretive approach. And indeed, strictly speaking, that is the approach that has been adopted in this appeal by the Upper Tribunal again, although it, in giving permission to appeal, it didn't consider any substantive issues. It simply considered it was bound by the position had been settled on previous occasions at that level. I have in my skeleton argument set out something about the historical and legislative history of shared ownership. I don't intend to repeat it in any detail. For one reason, we've not actually given you the underlying material in many of these cases, but I don't think it's really disputed.
and provided valuable background. Thank you.
It provides, I'm grateful for that. But there are a number of points that one can draw out of that. The first is that the term shared ownership is not a term of art, or shared ownership lease is not a term of art. There are historically and in legislative terms different forms of shared ownership. Sometimes they may involve different statutory definitions of shared ownership leases. Indeed, in the case of the 1980 Housing Act, 3 different definitions of shared ownership lease in various parts of the same Act of Parliament. And there are, in addition to that, as was commented on by the President in Canary Gateway number 1, forms of shared ownership lease which are outside the conventional structure of the Housing Acts and public funding, public subsidy. And the origin, there's a reference he made, and he was referred to it in that case, called Joseph Rowntree, which was a case involving charity law, but nevertheless it referred to various models of shared ownership being considered way back in the earliest days of shared ownership. There is, however, one important provision, which again has been referred to below, and that is at section 174 of the Housing Act, and you'll find that at page 107 bundle of the authority bundle. Sorry, page 3. There we are. My very first reference to the authorities bundle, and indeed the first page. Not only did I refer to the wrong page, but we also managed to get the wrong provision into the authority bundle. So this is the slip page that should make it in. Now, in fact, section 174 has partly been repealed. But in its original form, and you should have the slip page, it talks there about an exception for the purposes of enfranchisement of leasehold houses under the 1967 Act of a tenancy created by the grant of a lease in pursuance of this part, that is, broadly speaking, a right to buy, colloquially called right to buy leases, which is a house shall be treated as being a long tenancy, notwithstanding that it was granted for a term of 21 years or less. And we can see there that Parliament was specifically contemplating that some of these rare beasts under right to buy legislation should actually make specific provision for a sub 21-year lease of a house. And in respect of B, and this specifically applies to shared ownership, a tenancy created by the grant of such a lease in pursuance of the right to be granted a shared ownership lease should be treated as being a tenancy at a low rent, notwithstanding that rent is payable under the tenancy at a yearly rate equal to more than 2/3 of the rateable value of the dwelling house on the first day of the term, or more than the relevant amount specified in section 4. Now, the important point here is the words "such a lease." And that is a reference back to A. In other words, a term of less than 21 years. And although the latter provision has now been revealed, it does show that Parliament at some stage has contemplated very short terms when it comes to shared ownership leases. And the reason we say this, and the significance of the background to this, is that Parliament, when it comes to legislating in this area, has to deal with a developing sector when it comes to low-cost forms of home ownership. And housing associations and local authorities, and indeed the private sector, are ingenious when it comes to developing new forms of tenure. So when it comes to making provision for shared ownership, they very much have to look forward to what may be happening over a prospective period. So they work in my submission, and particularly in this area, they could be expected to work in a certain amount of flexibility to cater for new forms of tenure, which may not necessarily arise at the date of the legislation. If I can now move on to the specifics of interpretation, I quite deliberately start, not at my learned friend's starting point, or certainly the starting point in his skeleton argument, with the consultation paper. He dealt with it, I think, in a slightly different order today, but it must be right that the legislative material is considered at a later stage, once one has considered the meaning of the words and the policy underlining the words, and insofar as the legislative material assists with policy, that is a secondary consideration. It's dealt with at a later stage. If the meaning of the words is clear, one really doesn't need to look at the legislative material. It's a familiar position. I'm sure that one is addressed on this all the time. Now, my friend kindly averted to Settlers Court in the Supreme Court. I've referred to the treatment of legislative material. Indeed, this very consultation paper in Settlers Court. Settlers Court involved a very different issue, the extent of the property over which the right to manage was to be exercised, physical constraints, and indeed the concept of the pertinent property and exactly what the pertinent property meant. During the course of argument there, we spent, myself and I think this was one of the rare cases when my learned friend didn't manage to appear on the other side.
No doubt he was doing an identical case in another court.
I'm sure he was. But he ducked that for somebody else, who was, of course, successful. But nevertheless, we spent, I think, half a day arguing about the legislative material, and Lord Briggs managed to dismiss that entire half day, I think, in one paragraph of his judgment, where he said it was not determinative and just useful confirmation. That's the familiar position with legislative material. But in any event, if I can then turn to the starting point, as we must, I make no apology for the word, or for concentrating on the word or. As my lord said a moment ago, it must mean that the word or appears after each of the individual provisions, sub-provisions of section 76 to A to F. And the plain meaning is what we say the plain meaning is. If one is sent down to if one asks somebody to go down to the shops to buy eggs or bacon, they can satisfy that requirement by coming back from the shop with either bacon or eggs. That is the plain meaning. And in this particular case, we say that indicates on the most obvious reading that these are an individual series of gateways. Now, I'm going to come back in a moment to deal with the individual sub-provisions, which is in effect my second point on construction, that these are additive as opposed to being qualifying, and to deal with a very new point which was put in response to, or really an invitation from my lord to to deal with the the interpretation here. I too have struggled to work out how this could be treated as a series of sieves. Quite obviously, A, B, and C are alternatives to each other. And if one uses the conventional series of sieves, one cannot then change the sieves and insert an additional sieve at D and E. It just doesn't work that way. It is therefore necessary, if my friend is right, to add extra words to at least A, but probably B and C as well. Now, this is the first time in any of those, or in any of that oral argument, that has ever been suggested. It's a novel proposition.
I just wonder whether that can be fair, because if I look back at Mr. Justice Fancourt, paragraph 38, where he's referring to the debate's argument, he says in the fourth sentence, referring to the debate's argument, Section 76.2e deals exclusively with shared ownership leases, which are therefore excluded by implication from Section 76.2a. And is that not really the same point?
I had read that to deal with the additive point, which I was going to come to in a moment. It's a rather different matter, though, to supply extra words to this. And the question then is, what are those extra words? Nothing has been specifically put, is it? Are we saying A should be read with additional words subject to D, C and D below? How is it to be worded? One needs to, in order for them to qualify, one needs to insert that qualification at some point in A, B, C, D. And in effect, that alternative suggestion turns the division upside down, because one starts with D, E, and F, and the sieve then is in effect, it could be a sieve in that case.
Do you mind if we abandon this?
Yeah. It makes the specific then moving to the particular, to the general. And that's not the way Parliament has put it. So I say it's difficult to see the words. There's no particular reason to put the words in there. And that is not the way that the particular provision has been structured.
It is what you're saying, then, that A, B and C are clearly alternatives. Therefore, because this is one subsection in a list, A to F, it follows that they are all alternatives.
Well, they're alternative gateways, as
Yes.
it's put. The gateway analogy does work. They are alternative ways that
Yes,
one...
that's what I'm saying. So why would only the first three be alternatives? And
Yes,
then the last three be qualifications?
Exactly.
I think is
and
when I
in order
escape
to-
from the sieve,
Yeah.
I think is what you're telling me.
In order to get around that, one needs to, at some point in A, B, C, D, E and F, one needs to then supply some extra words. And it's not easy to see what those extra words are, or indeed where they should appear.
But you don't even need that on your argument, do you?
On my
because
argument,
you're
I
saying
don't.
if A, B, and C are all alternatives, then the fact that they're all alternatives is reinforced by my Lord Justice Newey's point that there's your all in the penultimate one to round off the list.
Yes. Now, if I can just take you very briefly to these various subdivisions. I accept that, with the sole exception of 97.2e, on my friend's interpretation, the number of leases which would be covered under each of B, C, D, and F would be minimal. Indeed, it's difficult to quantify them, but they really would be, as the term has been used, vanishingly rare. 97 to B deals with leases that have no term of years at all, which vest, I think it's for 2,000 years under Schedule 15 of the LPA. Paragraph C applies. I think it can apply to a tenancy of any length, including a monthly tenancy. I've cited authority. I don't think it's in dispute. But again, a fairly rare beast. Which then brings us to the discussion about right to buy leases under 76.2d. Now, the position with those is set out to understand how this works. First of all, as has already been said, in practical terms, under the right to manage, they are any lease where a local housing authority is the reversioner, is excluded from the right to manage under paragraph 4 of Schedule 6. You don't have it in the bundle, but it's there in the list of exclusions in Schedule 6. So in the vast majority of right to buy leases, they will not be covered because the local authority remains the reversioner. But putting that on one side, it will cover, there are possibilities, and I don't accept entirely my friend's analysis of the way that such leases arise. You've been taken to the Housing Act itself, and in particular to paragraph 12 of Schedule 6 of 1985. I'll take you to page 4. Now, just standing back from 12, before I deal with each of those subsections, 12.1 predominantly, in practice, applies to the grant of a lease of a house.
Sorry to interrupt, I don't think I've got paragraph 12.
Page 4 of the authorities bundle.
Schedule 6.
It's Schedule 6.
My authorities bundle, for some reason it jumps from page 3 to page 5.
I wonder if this is because the original version was double-sided, but the substitute page.
Yes. Thank you. I was wondering what was going on when Mr. Bates was My penny's now dropped. Thank you.
Now, these are the provisions that tell you the length of a right to buy. And the starting point is that the very first lease in a block of flats, or the lease of a house, one grants a term of 125 years. That's what happens. Subsection 2, or subparagraph 2, paragraph 12, is that in any other case, the appropriate term is a term expiring 5 days before the term of the landlord's lease. So if there's a head lease, it's got to be shorter. And that's the origins of what was said about those kind of leases, as whether it's in practice possible. But I do not accept that leases are all granted for 125 years. Indeed, right to buy leases, the majority of them, certainly in urban areas, now are granted for terms of less than 125 years. And that is because of 3. And what 3 says is that where there's a, broadly speaking, a block of flats, the first lease that is granted under the right to buy is for a term of 125 years. After that, the second and third right to buy leases that are granted in that block of flats are granted for terms coterminous with the first lease. We are therefore in the current market in the position where in central London in blocks of flats, many right to buy leases are being granted for terms approaching the all-important 80-year cut-off date for marriage value. There is a potential crisis a few years down the line, maybe 3 years or 4 years down the line, where such leases will become unmortgageable, of course, and where there is leasehold enfranchisement rights will not apply to extend the leases. Now, the consequence of that, and I come back to what I was saying about Parliament legislating for the future, is that it's possible to conceive in another few decades that unless somebody steps in and deals with that mortgageability crisis, that we are going to be the local authorities will only be able to grant right to buy leases for under 21 years. Because the first lease in the block was granted back in the 1980s when the right to buy was introduced. So it is possible to conceive of such leases being granted in future, although I would accept that for the time being, it's unlikely many of them would be granted, and even fewer would be granted that won't cause caught by the exception in paragraph 4 of Schedule 6. So it's for this reason, I think, why we do not pursue the otiose, the argument about provision, some of these sub-provisions being otiose. We don't accept that. We say that instead, what Parliament has plainly done here, in a sequence of sub-paragraphs to the operative provision, is to provide for, first of all, a general right in respect of sub-21 year leases of over 21 years. That's the ordinary definition of a long lease in other legislation. But then to provide for very rare circumstances, or where there is a lease of under 21 years, or not for more than 21 years, to which rights are extended. And one can understand the policy behind some of these, behind doing that, is that, for example, if somebody is no longer under D, if one no longer has a local authority landlord for some bizarre reason, you would therefore not be caught by, not be excluded from the right to management in the housing legislation, in particular the right to, the collective right to take over management through an ALMO, as they're called, and one can see this actually highlighted in the policy paper that I've mentioned, that local authority right to buy leases are generally excluded under Schedule 6 because of the collective rights to take over the management through an ALMO. But if that disappears, that right disappears, because the local authority, although it granted a right to buy lease, is no longer the landlord, one can no longer therefore use the ALMO powers of management, then in those very rare circumstances, the rights to the private sector right to manage is reacquired, and one can see that. Now, if one looks at it in those terms, in terms of policy, the position of E fits into that policy argument. Would Parliament have specifically decided to exclude the many hundreds of thousands of shared ownership leaseholders who existed in the market at the time of the legislation, certainly thousands who existed in the legislation, in a list which is first of all designed to add to the powers of, add to the list of long leases, the deeming provisions, and secondly, if it had wanted to do so, it would have flagged that up in words that were very clear that it was going to do so. And it would have flagged that up in the policy paper, it would have consulted on that, and it would have flagged it up in the legislation itself by using specific words. So it's not just a question of the plain meaning of or, nor the generally additive effect of these provisions, but it's also the policy, the most obvious policy reason behind that rather odd provision of E. And we say that it fits together, and in relation to the or and the additive approach, that has been the approach that was adopted by the courts below, tribunals and courts below, in all but one case, and my friend, I think, doesn't seek to rely on a single case that found it in that way, nor do we in respect of other cases which predated Nat and Osmond and so on. So, broadly speaking, that's the reason. I could take you to the policy paper. My submission, there's very little to be gleaned from it. You can't really approach a consultation paper which predated the consultation, let alone the legislation itself, with some gap in between. You can't approach it with the sort of close textual analysis that you would adopt for a statute or indeed the provisions of a lease or a deed. It just doesn't work that way. If you look at the policy paper, and I would return to the authorities bundle. I have a little bit of time left. In terms of the authorities, right at the end, and the passage that my friend is relying on, these, I hesitate to try to give you the precise chapter of this very long document, but it's paragraph, I've given the reference, I think, in my skeleton argument, but we're talking here about paragraph 13.
Yes.
On page 252 of the file. And one really has to read the whole of the paragraph. For consistency, we propose that in general, RTM should be exercisable by those leaseholders who will be eligible for collective enfranchisement under the Leasehold Reform Housing and Urban Development Act of 1993. I just pause there. What it says there is, in effect, nobody was giving a great deal of care and attention to the wording of these provisions that we're talking about, because they simply imported wholesale the provisions from another piece of legislation. And it then goes on to say, see Chapter 2 for details of proposed changes to the eligibility criteria under the Act. And I should just pause there. I've looked at Chapter 2. It doesn't mention the golden words shared ownership in this context at all. It doesn't talk about that at all. The right would be exercisable by qualifying tenants as defined in the 1993 Act. Just pause there. Again, they are importing the 1993 Act definitions. And then it goes on to summarise those provisions. And in my submission, imperfectly summarise those provisions. These are essentially leaseholders with a lease which was originally granted for a term certain exceeding 21 years, where the lease in question is a shared ownership lease. The leaseholder would have to hold a 100% share of the equity. One could add the word "or" in there, and it might make a difference. But in my submission, all they were doing was trying, and perhaps imperfectly, to summarise the given provisions of the 1993 Act. If it was a policy position to exclude shared ownership leases, as I say, one might well have expected that to be flagged up, given the effect on many thousands, if not tens of thousands or hundreds of thousands, of shared ownership leaseholders who have not staircased to 100%. There's nothing in there. There's simply no, it's a statement. It's not a statement of policy. It's a statement of what it analysed to be in the 93 Act.
May I ask a question, please?
Yes.
The title page of tab 15 refers to a draft bill and consultation paper. Was the draft bill that was annexed to the consultation paper in the same terms as was in
The answer is yes. I can just pause there. It is really difficult to get hold of the draft bill.
Right.
Really, really difficult. I have a copy on my
But you
shelf.
keep it in a safe
I keep it in the safe.
in case
and
Mr. Bates steals it.
I have my own under lock and key.
It's one of those oddities that we can all get hold of the consultation paper. Draft bill is
I mean, the only reason I ask
yes,
is
it is in the
one
same
can tell whether or not the summary is accurate by checking what the provisions of the draft bill are.
If there had been material differences between
Yeah.
the draft bill and this, I would have flagged it up.
Yeah. Okay, well that's great. That's great.
As I did in Settlers Court, to no effect. But in any event, I wouldn't. I don't think it's in dispute. The draft bill was in.
But we have your submissions on paragraph 13. One as we have your submissions as to paragraph 13. One as to how to read it, and B its relevance in any event.
So I don't need to add on. So on the appeal, that is broadly it. I don't really have much. There's quite a lot of detail in my skeleton argument, but in essence, as Randy says, it's a straightforward issue of interpretation, and we say the ordinary and plain meaning and the policy behind it indicates exactly why these are a series of gateways. I come now to the respondent's notice and the cross appeal, and my friend did indicate that there was another issue, but before I get on to that, if I can just take you to the photograph that you were shown in the supplementary bundle. I'm glad we are making some reference to the bundle. Certainly the supplemental bundle. I haven't, we would, I don't refer to anything in my skeleton armour. But what we have is, and I just want to correct one factual issue, although I've got to be careful about giving evidence myself in this respect. It doesn't in practice make any difference to the outcome of this, although it may assist a little bit with with what can be expected in particular circumstances. In fact, the photograph which shows Vale House is not entirely accurate. Okay. There's a concept in housing policy called pepper potting, or certainly those who design social housing things, which essentially involves a movement from the old days when social housing tenants were hived off in separate buildings, sort of an apartheid approach towards them, to having mixed communities.
Yes.
And what has happened at Vale House, certainly my limited inspection, is that this is a pepper potting scheme.
All right. So the part that we're dealing with is the affordable housing part of that block that the developers were obliged to.
There is a separate entrance to Vale House, but my recollection is that essentially it was one floor, but I may well be wrong.
Right. But I don't think it goes to...
Doesn't make any difference, but I think that, but it illustrates an important point here, which is developed from what my friend was saying about the earlier provisions of the Act. The right to manage is exercisable in respect of premises as defined in the Act, which may well be a building or a self-contained part of a building. And it's exercised by a qualifying majority of leaseholders within those premises. And it matters not whether those leaseholders, the artificial divisions that are shown here between Vale House and Elite House and Edgemere House are irrelevant from a legal point of view, what you have to consider, because they are all leaseholders, qualifying tenants, within part of the premises. And to that extent, it probably doesn't matter if there's part of the vertical walls, whether one can sever Vale House partly vertically from the rest of the building, or whether it's pepper potting or not. It does simply illustrate the point that I'm making. It's one set of premises, and it's a number of qualifying tenants within them. What we are agreed, and we can put on one side the largest category of leaseholders, who are conventional private sector leaseholders who have been granted leases by the private sector development partner. And we then have to consider the remaining ones, Metropolitan Housing Trusts, two forms of flats, one granted on shared ownership leases, some of which have been staircased to 100%, and a larger group of social rented tenants of the flats which are retained by Metropolitan Housing Trust, which in the Canary Gateway #1 case, Metropolitan Housing Trust was not served with any notices in relation to that larger category. I think it's 23, and they weren't served in respect of shared ownership leases. They were served on the notices of invitation to participate were served on the shared ownership leaseholders. What we have for Canary Gateway #2 is actually a different scenario. Those instructing me sought to comply with what they thought was the position that had been settled by the Upper Tribunal. And one can imagine their shock to find that 2 years later, having spent a great deal of money on the first set of proceedings, that we're here to relitigate those self-same points when they thought they had simply done what the Upper Tribunal told them to do, which is to serve on Metropolitan Housing Trust. And there is no dispute that in relation to the social housing units, the respondent served a notice inviting participation on those. Now, my friend is correct to say that at no stage has anybody looked at those notices inviting participation in terms of a court or tribunal. But it was no part of the argument below in the LVT that notices were or were not served on the 23, in relation to the 23 social rented flats. There was a statement of case. The tribunal ordered the appellant to identify its grounds of objection, and it didn't make any objection in relation to the service of those notices inviting participation on the social rented, in respect of the social rented tenants. So there is a factual difference. And before I come on to my Nat and Osman points, the way our analysis is that we say Canary Gateway if you are against us on shared ownership, we have not served, we accept we have not served individual notice of invitation to participate on Metropolitan Housing Trust in relation to its shared ownership leases. But we certainly have served them with 23 other notices, so elsewhere. What we say is, first of all, Nat and Osman, a correct application of Nat and Osman principles, one would, using the objective test of, there is an element of Nat and Osman which deals with prejudice, but it's in an objective sense as opposed to a subjective sense. And we say that applying that test, Canary Gateway #1 was probably wrong. That's what we say. Our fallback position is that the facts are different, because we in fact served 23 other notices of intention to participate on exactly the same tenant, qualifying tenant. That's Metropolitan Housing Trust, assuming it's the qualifying tenant. We say that's relevant. Now, my friend's response to that is, first of all, Nat and Osman doesn't apply because there is a trigger provision in section 78(2), and he relies, I think, in particular on the President's decision on Canary Gateway #1. So Nat and Osman simply doesn't arise. If he's wrong about that, then we're wrong about nationalism and engage in the arguments about substantial prejudice and the tests that he's referred to and that we refer to in our skeleton argument. The problem is that one can't leave it there because in order to say that it's a triggering event, my friend has to he has to not only show that it's a trigger, that it's an absolute bar on giving a notice of claim under section 78(2), but he also has to show that in this particular case we didn't give notice.
Would that not be a prior point? I mean, if you were right about that, you don't get into any of this anyway, because the notice you've served complied with the Act. And you don't have to worry about the consequences of failing to comply with the Act. So then it's a question of interpretation. Do you have to serve individual notices, or is it enough to serve... Well, of course, this is slightly different because you did serve individual notices. Can one, as a matter of construction...
Can I come on to that to explain how I consider the consequence of that is? What I say, with respect, what I say is the next stage is to consider whether section 78(2) has in fact been complied with. One can only do that. My friend can't succeed on any of it, and that is, as your lordship says, actually, in a sense, a more fundamental question than the whole of the Nat and Osmond issues, because and what my friend says on that is there is a requirement under the legislation that one gives one notice per flat, and what we say is under section 78(2) and under section 76(1), it's sufficient to serve one notice inviting participation for the whole of or one leaseholder. If that leaseholder has more than one lease, it doesn't matter. But one only has to serve one notice.
And I suppose that breaks down into 2 points. One, was it open to you in the terms of the statute to serve one notice on Metropolitan Housing Association or Trust or whatever it is, which by its own terms was capable of applying to all of the Trust's interests? 2, in circumstances where you haven't taken that course, but presumably have expressed your notices by reference to individual flats, can one read those individual those notices so expressed as applying to the totality?
Yes, but that issue does need to be ventilated if we're going to consider really the whole question of compliance, because whichever route you, whether it's the under our notice, respondent's notice, or under the my friend's response to the notice, somehow or another we have to decide whether there has to be established as a fact whether or not we complied with section 78(2). And that requires to resolve this dispute between the two sides as to whether it's an objective requirement of the Act for there to be one notice of intention to participate per flat, or one notice of intention to participate per qualifying tenant within the building. And on that, if I can, and I apologise for this point being dealt with right at the outset of my respondent's notice, but in my submission it does need to be dealt with.
I have to say, speaking for myself, it does logically come at the beginning of the respondent's notice, but on the other, it might be said against you, well, it isn't in the respondent's notice. But I don't think Mr. Bates is taking that point.
No, because he said he'd been alerted and he was grateful.
Yeah, so my learned friends draw my attention to this point yesterday, and I can deal with it in principle. I think the difficulty we're going to reach is we don't have these notices. I think what he's really asking for is remission back to the FTT to deal with this point.
Could one deal with it on the basis that we assume that each notice is expressed to be tied to the individual flat, and then one asks whether that would have been good enough?
I would respectfully say no, because I would want to look at these notices and see whether there's a point that emerges from the actual wording. I think my Lord put it right. There's two conceptual ways of looking at this. Could you do a global notice? No one claims that's been done here, but intellectually one needs to ask this question. Could you do a global notice? That wasn't done here. It's individual notices for different properties. So then two questions arise on that question. Can you treat a notice to flat 1 as being a notice to flat 2? As a matter of construction, in principle, can you do that on the facts of this case? And without having seen those notices, I'm very reluctant to get to that second question. Because I accept they've been served, we didn't challenge that. And I could proceed on the intellectual assumption that it's a notice to flat A, but I don't know whether I could accept, and I think I'm probably wrong to accept, that as night follows day, it must be read as applying to the others. I can have the in principle argument. I think what he really wants is remission on that point. And I wouldn't oppose that, because it achieves nothing to kick up a fuss about it now. He can just serve fresh notices and we'll be back here again. And answering that question is important.
I would be grateful if the way we can do. I appreciate. Obviously, I could take a point on the way that it was dealt with in the LVT, and that no issue was taken about service at these points. But I'm not going to take that. What I would suggest is that one makes a determination on the general principle as to whether whether it would be sufficient to serve one notice of intention to participate in respect of multiple qualifying tenancies.
I just wonder whether that does work. I mean, I quite follow. If you had served a notice,
if there's an issue, it can be remitted back to the LVT to make a finding of fact.
Yes, I mean, you say, is it possible to serve one notice? But I dare say it is, in the sense that if you served one document which said it applies to flats 1, 2, 5, 10, that would be fine.
I was going to come to that. The requirements are not even to specify the premises in the notice.
So
it doesn't have to specify the premises. No reference.
So the next question is
itself to the premises.
Right.
To the individual flat.
So the next question is, if you don't specify any properties at all, is that possible? Debate potentially over that, but that doesn't answer our question, because that's not what you did.
No.
Well, I don't think it's not in dispute that we served a notice of intention to participate on the in relation to the multiple flats within the block.
But it certainly isn't apparent that you served one that didn't specify the flats. We don't know that at all. And the fact that you served lots of them rather suggests that you did specify the flats.
Well,
which takes us to Mr. Bates's point.
The notice itself doesn't have to specify the flats.
No, but we don't know whether it does or it doesn't, and that might impact upon both of your arguments, because if effectively someone's photocopied 50, 60, whatever identical documents and put them through the letterbox or put them a second-class stamp on them, then that's one argument. If each one has a gap which has the name of the particular flat before the second-class stamp is put on them, that's a slightly different argument.
The difficulty is that you can't, it may well be that this is wholly academic in the light of any finding in relation to the first ground, but it is, in my submission, difficult for you to resolve the arguments on the cross appeal without being able to answer that question, whether it's possible to serve multiple notices of intention to participate on in this particular case, it's difficult to see how you can deal with certainly my friend's response to it. Otherwise, we're talking here because of the need to look at the this isn't a totally hypothetical subjective consideration. Sorry, it's not. It's a. When you're considering Nat and Osman, it is an objective.
You sort of see. You say, well, you
You
might
have
need
to
to know.
look at the reality of the situation.
I mean, on one view, you say, well, potentially the notices we serve are perfectly good enough. We don't get anywhere near Nat and Osman.
Yes.
But supposing that's wrong, you say, well, it still might be relevant to know the nature of the non-compliance.
Yes.
In other words, whether actually, say, if we left out the identity of the flats, it would have been fine. I can see there might be a problem there.
Are we not sort of wandering in the direction of saying that the respondent's notice effectively can't really be dealt with? That if the appeal succeeds, then the impact actually has to be remitted rather than being dealt with by way of the respondent's notice. Not for either of your fault.
No,
but just the way that the case has evolved.
I think the difficulty is that both of us, having dealt with it so often, we're rerunning Canary Gateway #1. And I think to be fair, both of us missed the point that actually the facts are crucially different.
I think we've certainly for my part, I've been very grateful for your joint expertise.
Well, in which case, I think I can probably read the.
Could you just give us a moment?
Yes.
Let's just.
Yes, I was just going to say, strictly speaking, it's a component part of the appeal as well, but that's a different matter.
Miss Loveday, I think what we'll do is, I mean, obviously we've read each of your skeletons on the respondent's notice. We'll hear what else you wish to say and you wish to reply to in the confines of how much time we've got left, and then we'll work out when we're writing our judgments how exactly we deal with it, because then we'll have your substantive arguments, and if actually you've both wasted your breath because we think we can't deal with it for whatever reason, either because we dismiss the appeal or we allow the appeal and say it has to be remitted, we'll have looked at it.
I'm grateful for that indication. My skeleton is a very fleshy one, and you will have I really have very little to add. Can I just check my notes just to see if there's anything
certainly.
I want
See
to come
what
back
else
on
you
that
need.
my friend
Do
said.
please. I'm not trying to sort of cut you off.
No. I'm always grateful for an indication. I don't have to.
Particularly if it comes on the back of a constitution that have read it.
I think simply the simple point that I would want to develop briefly is that in relation to the response that has been made, we do not accept that the respondent doesn't accept that the provision operates by way of a sanction. If you look at 79.2, we say, and this is on page 17 of the authorities bundle, claim notice may not be given unless each person required to be given a notice of intention to participate has been given such a notice at least 14 days before. There are obviously different ways that you can read that, but we would say that the better reading is that it provides a time stipulation rather than a sanction.
Does that mean that you accept that if you gave the claim notice 13 days before, that would be ineffective?
No. What it would mean is that it would engage Nat and Osman principles as opposed to the shortcut, which is that Nat and Osman does not apply. We'd say it for two reasons. Three reasons. The first is it doesn't mention sanctions, it mentions a time limit. It's difficult to actually work out how you could express a time limit other than in these words without incurring without involve. It's difficult to actually provide a formula which didn't provide a sanction when you're specifying a time limit. If a time limit says you must do something by a particular time, that doesn't. It's not pregnant with a sanction in itself. That's the first thing. The second thing is,
mightn't it be said as well that subsection 2 is doing two things? It's stipulating a time limit as to which there might be one argument relying on that and Osman, but it's also saying you've got to have served the notice on particular people.
well, the 14-day time limit is illusory anyway, because if you've got, and this happens particularly with small blocks, if you've got 3 or 4 people in a block and all 3 or 4 sign up to agree to become members of the company, there's no requirement for them to actually be members of the company. There's no need for a notice of intention to participate at all. And the 14-day time limit disappears in those circumstances. It could be said. It's the alternative reading. Plainly, that's the way the president read it. But we say there's no particular reason to read it that way. It provides a time limit rather than having a separate sanction. If there was a separate sanction, again, one would generally expect there to be a separate provision providing for that sanction, rather than it being a hybrid in one sentence. The second point is whether it's a sanction, whether it provides a sanction or not, in my submission is part of the bundle of considerations in Nat and Osman. It's not a question of Nat and Osman only arising in those circumstances. And the third point, which I made in my skeleton argument, is that if one looks at the, in terms of the consultation paper, where it deals with the 14-day time limit, there's no suggestion there that it's a hard deadline with a sanction that applies to it. And the purpose of it, more importantly, the purpose of it is to provide a breathing space for leaseholders to consider whether to join the right to manage. I do appreciate that there's quite a lot in my skeleton argument. I'd invite you to look at, in particular, the points that are made in relation to Nat and Osman, in terms of the way the Act and the regulations work, and the essence of our point under Nat and Osman principles is that the process of signing qualifying tenants up to the right to manage is not a critical, that's the word used in Elam, a critical part of the process of exercising the right to manage, which deals with the acquisition of the right to manage from the freeholder. In any event, it's there in my skeleton. So unless there's anything else, those are my...
Just give me one moment while I turn my markings up of your skeleton. Thank you very much. That's most helpful. Mr. Bates.
Thank you, and I will hopefully be able to finish before the short adjournment. Can I deal and reply with the appeal and then the respondent's notice point? Yep. Because my learned friend put it as attractively as he always does in these cases, but it came down to the same point on the appeal. In that he says, well, there's a policy reason to read this as the broad category and then dealing with individual scenarios, and then he postulated a terrible, but I accept plausible scenario arising out of right to buy leases over a period of time. I agree, plausible. I'm not quite sure how common it is, but certainly a plausible scenario. Respectfully, if what Parliament was doing when it legislated for RTB leases in 76(2)(d) was future-proofing against that future doomsday scenario, where right to buy leaseholders have not got a local authority landlord, but are holding leases of less than 21 years in hand, and was for that category of person was legislating. Respectfully, that makes the point we were making in our appeal. That's just unbelievable. That's not what Parliament is doing. I appreciate that on my construction, I'm not sure whether I put it in terms of reading words in or simply the act of interpretation. I appreciate, I have to say, as my Lord put to me, that A is read subject to the others. But that's simply the act of interpretation. There's 6 sealed categories. Which one applies to you? Do you meet the conditions? And if they were really catching the future-proofing scenarios my learned friend suggested out, one might have thought that would have been drawn out in some detail in the policy material beforehand, because that is quite a niche problem that he identifies. More importantly, on the respondent's notice, because I think you have the arguments on the appeal.
Thank you.
It is, in my submission, important here to bear in mind the scope of what the argument could be and then what the factual position actually is. Scenario 1 is an RTM company serves a global notice on a landlord, doesn't matter what kind of it, housing association, could just be an investor, who cares. One notice, as my Lord or my Lady I think said, with a schedule identifying all that. Would that be lawful? Scenario 2 would be a global notice that simply refers to all of your interests at the premises. No schedule. You can expect a landlord to know what he owns at the premises, might be the argument. Scenario 3 is not a global notice, but it's a notice to flat A, which you say, as a matter of law, can be read to flat B. And scenario D is a notice to flat A, which, although as a matter of law could be read to flat B, can it in fact, as a matter of construction, be read as applying to flat B?
I wonder whether there's even a further one where you don't specify any property at all.
Quite possibly. But this is part of the difficulty with this. And my learned friend, I think, is right. He and I have been relitigating past glories rather than focusing on the facts of this one. It's why I don't oppose remission on this. It does seem to me that the difficulty is going to be identifying what was actually done and can that fit with the Act. But broadly, we would say, if you are minded to get into this, we would say that, firstly, you would have to, in order for my learned friend to win on this point and bring the case to an end, you are going to have to be satisfied that the notices for the relevant social housing flats are capable, in fact, as being read to others, and as we don't have them, there is some difficulty with that. But the broader point is we say there's at least 3 indications in the Act itself that it is one notice per flat, and not global, and not even reading across. And I'll take you to those 3 briefly. The first is section 111, subsection 5, which is behind tab 2. And this is a provision dealing with its own bespoke deemed service provisions under this Act. It's page 59 behind tab 2. And it's 1115, which is how the RTM company serves on the qualifying tenants. And you see they're given a power to give a notice to a person who is a qualifying tenant of a flat contained in the premises at the flat. So the deemed service provision indicates that you give it to each of them at their flat. And if you do that, that's good service, whether they get it or not. There's Upper Tribunal authority on that, and the rest are querying it. So the fact that the deemed service provisions identify per flat, we would suggest is an indication that this is a per flat provision. Secondly, although there's a danger here of statutory instrument tail wagging statutory dog, if we look at the prescribed articles behind tab 4, so these are the articles that all RTM companies must adopt, there is no power to deviate from these, and we go to page 86, Article 26.1 is how you apply to become a member, and you see on the 3rd line down, starting to the board, there's a form of words that you need to use to apply. There can be minor deviations, etc., but this is the starting form of words. I am the qualifying tenant of address of flat. It seems to indicate that you will be making one application per flat, and that is because in Article 33.2 on page 88, you get one vote per flat. So 33.2, assume there are no landlords who've joined the company for this purpose. If landlords join, there's an incredibly complicated change to the voting process. But assume no landlord has joined, then one vote should be able to be cast in respect of each flat in the premises. The vote should be cast by the member who is the qualifying tenant of the flat. So you need
This is slightly different. I mean, I've looked, I quite see your section 111.5, but this is slightly different because this is directed to an individual making an individual application, and so on their application form they're going to put their address. I
accept that. It's partly why I said I'm careful of the statutory instrument tail wagging the statutory dog. 1115 seems to me to be the critical one.
Seems to me that's your more important one. Can I just ask one question?
Yes, of course.
Although I suspect I know the answer. So I rather thought that in the same way that there's almost like a template for this, that you would have been able to tell me, both of you, well, this is what the notices look like.
Oh, what they do, behind tab 3. Behind tab 3, so in relation to notice of invited participation, claim notice and counter notice, the Secretary of State has power to prescribe a form.
Right.
It's behind tab 3. Schedule 1 is the notice of invited participation. Because of the way Westlaw stores these documents, the actual form here would have to be amended ever so slightly to catch SIs that have amended it subsequently. But this is the 95% of the model form for the NIP. Schedule 2 on page 71 is the claim notice.
Yep.
And Schedule 3 on page 74 is the counter notice.
Okay. Thank you.
So just to make good my little point there, if you look at page 76, the notes on the counter notice, you see note 2 refers to a leasehold valuation tribunal. Well, they only exist in Wales, of course, now. There is an SI that says that should read appropriate tribunal, etc., etc. Right. But the body of the form is still the same.
Thank you, that's helpful.
So that is the answer to that. Just one other point about membership and per flat. Again, in the Act rather than the secondary legislation. It's a question about how section 80 subsection 3 would work on page 19. we would suggest 83. So your claim notice has to state the full name and address of a person who is a qualifying tenant of a flat in the premises and a member of the RTM company. We suggest that would probably mean you have to indicate every flat they're a member of, because of course they're going to get one vote per flat, and you might well want to know that you're being invited to join a company with someone who can outvote you. But I'll say, I think the real answer is this may or may not be a very, very good point from my learned friend, but I think it's too difficult to grapple with it here on appeal for the first time. The real question is the shared ownership one, where you have both of our submissions. It really comes down to, is it sealed categories, as I say? Is it legislating for unlikely but possible scenarios?
Thank you, that's most helpful. Any other questions? No. Thank you, thank you.
Can I just rise? Obviously, I didn't develop any arguments in relation to one per flat. I don't know if you would want me to address you in bullet points as to why we say it's one per qualifying tenant. I did have arguments. My understanding from your indication earlier on was that you didn't want me to address you on that.
Give me them. I think what we think is really what Mr. Bates has done now is, rather than developing the argument, as he said right at the end of his submission, giving us pointers as to why really this court isn't going to be in a position to resolve that, because neither of you are able to fully develop those arguments.
I don't disagree with that.
And really, it was almost supporting his argument that if we get there, then that this is an issue that should be limited. So we perfectly understand that there would be other matters which you would wish to raise, and if we are dealing with it, the judgment will ensure that that's very clear.
Yes, I'm obliged.
Finally, might I thank our learned juniors for their work done getting this appeal ready, so that my friends and I could have this fight again, and congratulate them both on their debuts in your Lordship's Court. Your Lordship's Lordship's Court.
Certainly. Well, thank you very much indeed, both of you, and welcome to both the juniors to the Court of Appeal. I hope you will go away telling your colleagues in chambers that we don't bite.
I think they can see it on television.
when you watch yourselves on television. We are very grateful. I mean, we're very conscious that the juniors always do a huge amount of work in these cases to get them ready, and both the bundles and the presentation in this case have been exemplary. So thank you both very much, as well as your leaders. You won't be surprised to hear that we are going to reserve our judgments in this matter. I'm not quite sure when you will get them. We're conscious that that quite a lot turns on this very short point, but as you've rightly pointed out, there are a very large number of people who are affected by this, and so we want, of course, to take great care to consider your judgments before reducing our views to writing. They'll be sent out in the normal way, electronically, for typographical, minor factual errors and the like, not as an opportunity to re-argue, please. If you would just take careful note of the new embargo that appears at the top of draft judgments now. We are taking it very seriously. There's been a couple of very unfortunate mishaps, so please make sure that we get the appropriate list and explain to those who instruct you, or further behind, the people involved by your lay clients, that this is not a decision you're making, but that you're obliged by virtue of the embargo.
I wonder if you are going to be handing down judgment, I don't know when that would be, but if you could just indicate that council's excused attendance.
Oh, well, we no longer, because since COVID, or the pandemic, all judgments are handed down electronically now. We don't have the pantomime of one judge walking in, handing down a paper copy to an empty court and wandering off again. So everything will be done electronically. And I'd hope if there's, then you could agree an order. Obviously, costs are already agreed, but if you could agree the terms of order, any difficulties outstanding, we'll hear written submissions. And thank you all very much.
All rise.